Well, greetings again. Today we're going to take up Lesson 27. Now we're going to go on the offensive, and Lesson 27 deals with offensive law. We've just completed the lessons on the courtroom strategy, the courtroom drama itself, the courtroom presentation. And now what I want to talk to you about is the hunter, or the hunter becoming the hunted, and the hunted, which is you, the defendant, now going on the offensive, to bring to justice, so to speak, those of your adversaries and persecutors who may have had you falsely arrested and imprisoned. They may have taken your property without due process. They may have taken your wages without a court order. And the question always comes up, well, what do I do? And people say, well, I can sue them. Oh, you can? Well, then how do you go about it? What is it exactly that you're going to do? The IRS has a habit now of fining people $500, sending the notice of judgment from the IRS to your employer. Your employer takes $500 out of your property, your check, your money, your labor. They send it to the IRS, and people say, well, now what do I do? Well, what you do is you sue somebody. But if you don't know how to sue someone, and if you're not judgment-proof, you know the results of the suit can be even worse than the loss of the $500. So in offensive law, there is a new strategy and a new technique. And you must be judgment-proof, because if you're not judgment-proof, you're apt to find out that it's going to be so much more costly to you to try to get back what's been stolen from you, that the loss of the suit may be so much greater than what's been stolen that it isn't worth it. So let's run over what we want to cover, and here's a typical offensive action. And so with this lesson, I'm going to give you, one, the summons and complaint, and that comes in a spiral binder, and I've gone through and separated out all of the respondents, that is, all of the defendants in this case, reply to my suit, and I'll explain this to you. And this happens to be a civil rights action under Title 42, and I'll go through that in great detail, and I'll show you exactly how you, the hunted, now are going to become the hunter. But let's take a look at what we're going to need. In Lesson 27, Offensive Law, notices, affidavits, restraining orders, show cause hearings, interpleaders, and then Title 18 and Title 42. And that's just the beginning. Because in a common law action, you may not file a Title 42 suit, which is a civil rights action, a civil law action, so to speak. But you may want to file a common law action like a replevin or a trover or a tort or trespass. And if you're filing actions like that, those actions have specific intent. You can't file a trover if you're going to sue someone for a civil rights violation, and you can't file a Title 42 Section 1983 action if you're trying to recover property. You'd want to have a replevin or a trover. So to begin with, there's a thing called the action. And you're going to have to determine what kind of an action you have. And the type of action you have will be determined by what it is, what kind of a damage, or what it is that someone has done to you. Now, for instance, I've mentioned the automobile and the motorcycle case. And I elected to do a trover, which is a common law action for recovery of property that's been converted. And that's called an unlawful conversion, and it's a common law action. All right, now that was my election. I could have done a replevin. I could have done a trespass. But I couldn't do a civil rights action because that wasn't appropriate. Now, because I did a trover, once you've made your commitment and you said, well, I'm going to file a trover, and you filed the action, there's no backing out. And that's why it takes some time, effort, and energy and some wise counsel before you file the action. You want to determine what kind of an action you want to file. Because oftentimes a case will get to the Supreme Court and they'll refuse to hear it because it's the wrong kind of action and they don't have jurisdiction, or because the pleadings were incorrect, and a dismissal can occur. And you've only got one shot in a civil action. And your chances of winning the civil action are 25% statistically. And that's if you're right, and that's if you've got a good action. Most actions that you hear of is where a fellow was arrested for drunk driving and taken to jail, and they took his fingerprints, and he's botched it up. Maybe he voluntarily gave him his fingerprints and then wants to come back and sue. Maybe he was roughed up a little bit. No, you may have an action technically, but the practicalities of the situation are that you really don't have an action. To have a good action that you have a chance of winning on or making some money on is going to require some real damages, and anything less than a week in jail or severe fines, deprivation of property, that is where they've taken, a few $100s. It doesn't have to be a mountain of money. It can be a judge who fined you $60 and when you raised the money issue, threw you in jail for 12 days. That's an action, because now you've got 12 days in jail, and I think that $50,000 a day for every day that you're falsely imprisoned, in addition to the false arrest, is about the right amount in a civil rights action, and that's the number that I've picked. Now let me tell you a little about a civil rights action that came down so that you'll know what not to do as opposed to what we're going to talk about doing. A lady came over to the school from Oregon, and it seems like that she's a very patriotic and a very zealous patriot, and she wanted to challenge the gas pump licensing. Now, first of all, licensing of gas pumps affects a public interest. I think everybody would recognize. It's also dangerous because they can burn or they can blow up if they're not maintained correctly. I think the state, when it comes to licensing gasoline pumps that are used to serve the public, is probably a proper police function. I think that probably into the police powers it's correct. But anyway, she wanted to challenge it, and so they did, and they didn't get him licensed, and then the state sent out a ringer, and he bought some gas, and they took his money, and they arrested this lady's husband and took him to jail. Now, my first impression, or the first reaction that I got when I heard the story was, uh-oh, you're in deep trouble, because I don't think you've got an action. Well, they went ahead and they filed a Title 42 suit, which was about as thick as this, and this is 90 pages. This is a pretty hefty suit that I filed. And she sued a judge or two and several state agencies and several state officials, and she'd named something like $300,000 or $400,000. Now, when she wrote the suit was very poorly put together. It did not have all of the indicia that were necessary to file a Title 42 suit. I'm not sure that a Title 42 action was the proper way to go anyway. I think that she had probably a trespass action, if anything, but nevertheless, maybe, if we stretched it, there might be a civil rights action. And then they counterclaimed for $300,000. Her case was dismissed, and one of the judges that she had sued gained a summary judgment for $300,000 against her, and guess what? She told me that she owned all of her property in Allodium. And I says, oh, well, what has that got to do with anything? Well, they can't touch my property if it's in Allodium, can they? I said, no, all that does is means that it's free and clear. It's a little better title than if they merely took an equitable interest away from you. Oh, well, I didn't know that. And then, how much property do you own? Oh, well, the Veterans Administration has the mortgage on it. And so this lady didn't even know what an allodial title was, or what fee simple meant. She had an equitable interest in some property, and she thought that she'd filed some kind of an allodial title with the county recorder. Well, just filling out a paper and filing it with the county recorder doesn't make the property allodial, or allodium, or in allodium. And then it comes to, we found out she owned 3 or 4 pieces of property. Well, now, the problem that you have here is that she's not judgment-proof. They've got a judgment against her that can be executed, and when they execute the judgment, they'll take all of her toys away from her. So she sued, got nothing, was countersued, and can lose everything. So the first rule that I follow here at the school is, if you're not judgment-proof, do not sue. It's just that simple. Because even if you're right, your chances of winning are only 25%. And if you've got toys that are valued at $100,000 and you're going to sue somebody for 20 or 30, if and when you lose, you are going to be charged the court costs and attorney's fees for the prevailing party. Now, on the Trover action with the car and the motorcycle, I was presented with a bill for $6,800. Now, fortunately for me, my government's already taken all of my toys away from me. So I don't have any houses or cars or barns or lands, and I don't have any income because I'm unemployed. And I've been retired for several years, and so for that reason, you can get a judgment against me, but what are you going to do with the judgment once you have it? And then, in addition, I qualified my case for the Supreme Court, and so I'll be appealing and bringing up motion hearings and litigation for the next 3 years. So the $6,800 that they have in judgment against me is going to grow, because if ultimately we get to the Supreme Court of the United States and the Supreme Court upholds their position, and I'm the loser and I'm the plaintiff, and there's a $60,000 bill, I'm going to have a $60,000 judgment against me, and if I've got a $60,000 house, they're going to take it away from me. So my common sense tells me that, do I want to risk a $60,000 house in trying to recover my car and my motorcycle that are only worth $3,000? And they accused me by saying that my car and motorcycle were really only worth $200 or $300. Well, gosh, I could be risking $60,000 to only gain $300 back. I'd be better off to let them just steal it, wouldn't I? That's why it's so crucial for you to be judgment-proof, and those persons who are going to go forward here at Lesson 27 and take offensive actions must be judgment-proof, or the risk, in my opinion, is simply too great. And I doubt seriously that I can win the first, second, or third cases that I do. Because remember, now I'm the plaintiff and the burden of proof is upon me. My chances of winning are only 25%, and that's if I'm good and if I'm right. So with that kind of odds against me, and with those kinds of odds against you, the first thing we've got to do is to get our status straight. So you must make yourself judgment proof. And while I'm not telling you what you must or must not do, let me tell you what I did. I got rid of all of my toys. For instance, I sold all of my real estate, and then I went right straight down to Reno and I gambled it all away because I didn't want to have any money. I took all of my cars and I sold them all. I borrow a car from a friend of mine. There's one out in front of the studio right now. I don't remember what friend loaned it to me, but some friend bought it and lent it to me. I don't drive Maseratis or Ferraris. I drive a 1972 Pontiac, and then I have my famous 1967 classic black Chevrolet Impala. Now, those are my cars. Now, if you've got nice Porsches or something like that a lawyer would like to take away from you, my suggestion is that you get rid of it. Now, a lot of times people ask me, well, what do I do to get rid of the property? Well, there's a number of things that you can do. Why don't you sell your house to someone else and do it a couple of years before you come up to a suit? Because, you know, it's concealing wealth or concealing your assets after the judgment has come down, and when you're concealing assets, you can have those taken away from you. I've heard of people putting them in blind trusts and of one type or another, you know, a week or two before a judgment comes down, and then they've been broken. Now, or it's an obvious concealing of assets, and then they've stopped the deed transfers and things like that. So I like to cover things, as I've said before, in advance. I like to plan the action a long time before it occurs. I know that I knew 3 years ago that I was going to file some civil rights actions, and so it was 3 years ago that I got rid of all of my toys. I'm unemployed, I'm a deadbeat, I'm a bum. You couldn't get anything out of me if your life depended on it. There are no debtors' prisons in America, so I can sue you, which is what's happened here. I sued these people for $700,000. It's going to cost them, and there's 5 law firms involved in the defense. These people have gone out and hired lawyers and I would guesstimate that they're going to spend about $25,000 defending this action. So when I filed the action against them, if they fail to answer and fail to defend, I'd take a summary judgment for $700,000. Now, if they defend themselves, it'll cost them $25,000. So the way that comes down is heads I win $700,000, tails you lose $25,000. And the way I see it, it won't be very long and it won't take very many of these suits until my adversaries decide that it's too expensive to deprive me of my rights and to steal my property. Now there's another thing that you have to be aware of, and that's being a litigious person. If you're a litigious person, that's the fellow who files a lot of lawsuits and common law liens and other types of legal actions against persons frivolously. And if you do that, you're going to be shut down. And here in the state of Idaho, there's a case called Miller versus State, or Miller versus somebody. I don't have the citation right in front of me, but essentially what happened to the fellow was this. He's a patriot, and he's up in the north end of Idaho, and he went out and filed 20 of these civil rights actions. And he tied up judges' properties and all sorts of public officials' properties, and he sued them because they didn't take their oath of office. And he's probably a nice fellow, and he's probably right about most of what he's doing, but unfortunately, when you have a bull loose in a china shop, the police powers have to come into play, or at least they do come into play to shut him down. And so they shut him down with a court order from our state Supreme Court, and in all offensive actions, he must have a licensed lawyer. Although in defensive actions, that is, when the government charges him with a crime, he still has all of his rights under the Constitution. He can defend himself, but he cannot take an offensive action. Now, a fellow came to me one time and he said, "We're going to use that Miller case against you, Mr. Gordon, and we're going to shut you down." And this happened to be a city prosecutor here in Boise, and I said, "Well, is it your position that you can use the Miller doctrine against me on defensive actions?" And he thought, yes, that's what we're going to do. Now, the poor fellow had been to law school, and it'll probably be another 10 years before he recovers from that experience in law school. The Miller case doesn't say that he can shut me down in defensive actions. It says he can shut me down in offensive actions. Now, I'm not the type of person who takes lightly the threats of my public officials. And so as I told him, "Well, friend, I'll tell you what, I won't file 20 lawsuits. I won't even file any common law liens. What I'm going to do is I'm going to sue you people 2, maybe 3 times, and then I'm going to go out and teach 20 other people how to sue you 2 or 3 times. And that way we won't have to be concerned about the Miller doctrine, will we?" And at that point he threw me out of his office, and he's never invited me back again. And so in Lesson 27, what I want to emphasize to you is, don't file 20 actions. Don't run around suing every policeman, every mayor and city councilman around who looks at you or calls you a dirty name. And furthermore, unless you've really got a good action, don't even waste time, because a lawsuit is like a peremptory challenge. When you go in, you don't want to throw your peremptory challenges away when you're selecting a jury, and you don't want to throw away your 2 or 3 lawsuits that you have that you're entitled to frivolously. You want to set the case so that it's a good case. The case like the goat scam or the drunk driving scam, you want to employ that so that you've got a good one. And it isn't bad to have about 5 actions. In other words, do the goat scam, do the drunk driving scam, do the driver's license, and etc. And then out of the 5, pick 1. Now, let me explain to you what happened on this case. Now, I can't speak for other people, but I personally do not take an oath. I believe that taking an oath is a violation of a scriptural doctrine at Matthew 5:33 through 37, which prohibits the swearing of an oath. Furthermore, I believe I'm a pathological liar, and I got that doctrine from Paul in Romans 3 verse 4, wherein he alleged or recited from and said that let God be true, but every man a liar. And so since every man, the scripture says, but every man a liar, and I am just one man, I concluded that I was a liar. Now, there's another scripture at James 5:12 that says again not to swear or take an oath. When you go into a courtroom, one of the first things they want you to do is to raise your right hand, your left foot, cock your head to the side, and go through a ceremony when they ask you this question. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Now, if you'll notice the words there, that's a question. They're asking you, will you do this? Now, when you ask someone a question, it can be answered one of two ways, yes or no. When the question was asked of me, I said no. And right away, the judge got very upset about that and said that if I wouldn't take that oath, he was going to put me in jail. To which I replied, sir, I don't want you to put me in jail for contempt because I'm not in contempt. This is a sincerely held religious belief of mine. I've told you plainly that I'm a pathological liar. I've told you plainly that I won't take the oath. He said, well, then will you affirm? My position on that is that to affirm is simply a euphemism for the word swear. You know, it's like saying, I won't call your mother a bitch, I'll just call her a dog. Well, what difference does it make which word you use? Bitch and dog are synonymous terms in the same way that swear and affirm are synonymous terms. So what they're trying to say is, well, if you'll use this other word, these other phonetic sounds, you see, that somehow changes the animal. If we give you a $5 Federal Reserve note, somehow that's as good as or takes the place of the substance called silver and gold. And I disagree with that. And so the judge put me in jail for 5 days. And he brought me back out of jail and said, will you take the oath? To which I replied, sir, why do you compel me to give up my religious rights and my religious freedoms and try to compel me to violate my religious conscience? And so he got angry with me and he threw me in jail for 7 days. Now, the issue of this Title 42 suit then is, when a man goes into court, can he be compelled to take an oath in violation of his religious principles or his religious beliefs? I contend, no, they cannot. And the state of Idaho contends, yes, pursuant to the rules and pursuant to the statutes, you can be compelled to do that. And so there's the basic issue. Now, while I was in jail, I was abused. They attempted to take my fingerprints. They threw me in solitary confinement. They twisted my arm behind my back. They denied me my right to have a pen and paper to write a writ of habeas corpus. And I spent a total of 12 days in jail. There was my damage. But you know, this is my first Title 42 suit, and it's not my best one. The best Title 42 suit I have, and after talking to a number of my Confederates, this is the principle from the book of Proverbs of seek out wise counsel, or there's safety in a multitude of counsel. So I talked to several of my friends, and they said, yes, we think that your lawsuit against the policeman who stole your motorcycle and your automobile is a better case, and you have a better chance of winning it. So I brought, of the 5 actions that I have, the 5 choices that I have, I picked this one because I plan to lose this. Yes, that's true. I don't think that I have the capacity to walk into a federal district court and argue a major case that'll probably take 2 weeks to try. We'll have at least 50 witnesses and will probably cost in the neighborhood of $50,000 to try the case. And I'm going to be faced with 5 lawyers over there against me, and I'm going to be sitting over here by myself. I believe the judge will deny me counsel, and so I won't even have a next friend over there to help me select the jury. And it's going to be 5 against 1. They're going to bring in expert witnesses. They're going to bring in people that are experienced and knowledgeable, who have been in trials and trial courts and criminal actions over and over again, who have cross-examined hundreds of witnesses, and who are so knowledgeable in the courtroom that by comparison, I'm a peon. That's what I'm going to be up against, and I just don't think I can beat them the first time out. So I thought what I would do is I'd go in with this case, which is a good one, and I'd practice on them. And the way I've got it figured, by the time I do 10 of these over the next 5 or 6 years, I think I can win one. Now, if I can win one suit for $700,000 in the next 5 years, and if they can spend $25,000 defending those 10 suits, it looks like they're going to spend $250,000 defending themselves. Isn't that right? I think that the insurance company underwriters are going to get tired a long time before they spend $250,000 fighting with George Gordon. I really do. And furthermore, I think that one of those 10 cases I'm going to win for $700,000, and if I win one for $700,000, I'll have the $250,000 to pay off all of the court costs that I have incurred, right? That would leave me with about $400,000, and I say that's pretty good pay for 5 years. Or they're going to stop harassing and hassling me, and the eloquence of my argument is going to make itself manifest in their bank account and their bank statements. I would say that by being a deadbeat, by being judgment-proof, by being knowledgeable and prudent, by taking the lesser cases first and practicing on them, that by the time I've done this 3, 4, 5, 6 times, I should start getting pretty good. I should start to get to a point or a place where I'm about as knowledgeable or about as talented as they are. And I'd like to point out that this is the very first Title 42 suit I've ever done, and I've been in this for about 5 years. So, if you think that it's just like falling off of a log, and I know that I have people in here that have already filed suits, they come into school from time to time and they say, well, now what do I do? When do I file the motions? How do I write this motion? Listen, friend, if you're still out here worrying about or trying to learn how do I write a motion, or how do I answer this pleading, or what kind of a pleading or what kind of a case should I file, and should I file the action under Title 42 or Title 18, is it civil or criminal? I mean, there's no point in even talking to a person like that, because he's so far out to lunch and off the wall, he hasn't got a snowball's chance, and you know where, of ever being able to win that case. He can't even get started on it. And furthermore, he probably is not judgment-proof. He's going to go in and lose, get a judgment against him, and have his toys taken away from him. All right, so if that's what you're concerned with, or if that's, if getting back here to Title 42 again, if you're concerned about losing your toys, well, then you can't do this. And if you're not concerned about losing your toys, you better be concerned about losing your toys, because I don't think I can win at the first or second time out. And so I don't think you can win your first or second time out, although I don't like to say people cannot. Now, I want to take a look. So take this blue-covered book. It's called right here on the front page, it says, in the United States District Court in and for the District of Idaho, and it says George Gordon Plaintiff versus all of these defendants. And let's take a look at some of the things that we're going to have to do in a Title 42 suit. We know this is technically correct because the filing was accepted. Now, I haven't won the case, and it'll be 3 years from now before we'll know how this case comes out. But I know this, that you at this point, or this juncture of your education, are going to have to now take offensive actions, because if you don't take offensive actions, what it boils down to is, I backed my car into the side of yours in the parking lot. You've got my license number. You know who I am. I thumb my nose at you and say, bug off. The side of your car is bashed in. What are you going to do about it? The IRS has sent a letter to your employer. Your employer took $500 out of your check. He's disregarded your W-4 form. What are you going to do about it? The State Tax Commission, ditto. What are you going to do about it? The policeman has arrested you, seized and impounded your automobile. They took you to jail, beat you up, took your fingerprints. What are you going to do about it? If you're not prepared to do anything about it in offensive action, then you're going to have to go back to Egypt and make bricks. That's all it boils down to. You're either going to do the offensive actions or you're going to be oppressed continually. All right, so let's start off with the first item. As soon as you open the file folder, you'll notice it says summons, and there's a civil case, 83-1144. And you'll also notice you're on long paper. In the federal district courts, these cases must be filed in short paper. So Rule 1, it's got to be done in short paper. Rule 2, there are civil rules of procedure in your district. These are the local rules. So go up to your local district court, that is your federal district court, and get the civil rules of procedure, and then you'll have to write to West Publishing Company and get the federal rules of civil procedure. You've got to have the rules, and you've got to have the rules in front of you. All right, now with that much, let's take a look at the summons. It says here, to each and every one of the above-named defendants at the addresses as follows. Judges Young and Grant, 514 West Jefferson Street. And if you'll go through, you'll notice that you've got a form here. This is the form to follow. This form, by the way, you can get from the Federal District Court Clerk. They have a form, and all you have to do is type in the answers. And this is called the summons. And the summons must be accompanied by your complaint, which is your next page. Your action will be a summons and complaint. Those are the two items that you're going to have to file your action. Now you'll notice that I spent a lot of time, effort, and energy on this particular summons and complaint. It's not an easy job. It does require a little typing. I mean, you're going to have some typing, some exhibits. Read through this in its entirety, and you'll find what it is you need to do to get one filed. We still don't know whether it's going to be thrown out of court or not, and I'll cover that in a moment, because I'll show you how I've cast my issue in cement. And this issue is going to go to the United States Supreme Court. Whether they like it or whether I like it or not, it's going to Washington to be decided by Moses. But before we get into that, let's take a look at a complaint. This complaint follows a procedure that comes from a book, and I'm going to send you the rules, and I'll just write that down right now. I forgot the name of the book, but I went up to the law library, and I went to my friend Laura, who is the law librarian, and I said, I want to file a Title 42, Section 1983 lawsuit against a policeman and some judges and sheriff's deputies. Where do I need to go? And she said, okay, follow me, and we went over to a book, and we got Form 10.41, and I'm going to send that to you. Now, for this particular kind of an action, the feds have all kinds of forms for it. If you're a policeman who's been fired or discriminated against because you're black, if you're a school teacher who's been fired by the school board because you're pregnant, if you're some other public official in some other type of occupation or employment and you've been discriminated against, there's a federal form that'll probably cover you or will come up close to it. Now, it happens that this was a violation of my rights. I was false arrest and false imprisonment, and so I took form number 1041, which was the closest thing to false arrest and false imprisonment. So I'm going to send you that form. That'll give you an example to follow. But remember, before you get into this, you should be knowledgeable enough that you've been into the courts a few times, and you should be able to use the law library and walk up to the law librarian and say, I want to file an action. Let's take a look at some actions. The complaint here has about 20, let's just see how many paragraphs. I see 27 paragraphs, 28 paragraphs. Looks like 31. Looks like about 30 paragraphs. Each one of these paragraphs answers a vital and significant piece of information for which the omission of any one of these paragraphs could render this entire document, this entire suit, null and void. That's how critical it is to get all of the factual information in. As an example, it says in paragraph 1 on page 1, Plaintiff George Gordon is a citizen of the United States of America and a resident of the city of Boise, county of Ada, state of Idaho. That states my citizenship, because if I fail to do that, the court's going to assume that I'm a Mexican national, a wetback who's crossed the river and doesn't even have a capacity to file this suit in a federal court. Now, it doesn't say that a Mexican national can't. I'm just saying that they're going to assume that. In number 2, you'll notice I said that defendants Richard Grant, Dennis Kane, Stephen Beer, Idaho Collections Incorporated are now and at all times material hereto and were duly appointed, employed, and acting in their official capacity as attorneys or judges in the city of Boise, acting in behalf of the state of Idaho under the color of Idaho state statutes. Notice, acting under color of, and Idaho Collections Incorporated is an Idaho corporation. The defendants are also residents of Boise City and or Ada County, Idaho. Now, that identified them. And going on, number 4 as an example says, this court has jurisdiction of this case under and by virtue of Title 28 of the United States Code Section 1343. Always make sure you check out the jurisdiction, and remember, you're the plaintiff. You must assert and prove jurisdiction, because remember, in your criminal actions, you've been challenging the jurisdiction of the court and the jurisdiction of the traffic court, or the prosecutor has failed to assert and prove jurisdiction pursuant to Thibodeau versus Maine, or Owens versus City of Independence. All right, so you've got to do it. And so the way we do this is we go look at Title 28 and make sure that Section 1343 is the appropriate jurisdiction in the federal court. And so I'm telling the federal court judge, you've got jurisdiction in this matter because it says so right here. Then you'll notice that we have, as we continue on here, which is called the complaint. Now this complaint is going to set out every material fact and allegation that you're making. And when you get into that courtroom, you've got to prove every material fact and allegation that you're going to put in the body of your complaint. And this is called the statement of the case. So you're making your statement of the case. And if you'll notice, it's simply a story flow. All it is you're starting back here at day 1. I was driving down the street, minding my own business, when I looked in the rearview mirror, and there were lights behind me from an emergency vehicle, and I pulled over and stopped, and the emergency vehicle didn't go by. It stopped behind me. I asserted my rights. The officer arrested me, took me to jail, and stole my automobile. And you relate all of these facts because these are material facts. Now, you've got to prove each thing that you say. So everything that you say in here, you need to be saying to yourself, now, who is going to testify to that statement? Am I going to testify to that statement? Is the officer going to testify to that statement? Is the witness who was riding with me going to testify? Do I have any physical evidence? Do I have the 3 tickets? Do I have the arrest warrant? Do I have the summons and complaint to the court? What tangible physical evidence do I have? I've alleged that they took my automobile and it's sitting over here in a wrecking company yard. Am I going to have to subpoena in a witness from the wrecking company to testify that my automobile is still there? Can I do it by affidavit? Can I do it by deposition? The answer to all of those is yes, you can, and yes, you're going to have to do that. You're not going to be able to simply walk into the court and sit there and go, well, here's the way this came down, Judge. You see, this guy did this to me, and gosh, that was wrong, and I want you to give me this money, and I think that's about right. Because you're not going to go anywhere like that. If you've seen a Perry Mason TV special, or remember the old Perry Mason shows that used to come on, and you have to delve into cross-examination, and you're going to have to trip up your opponents, because remember, they're going to deny everything that you say in here. They're not going to sit out there and say, oh yeah, I knew this was a violation of his civil rights. We just did it because we wanted to cower him into submission, because we were afraid that if he were to get away with driving without a license or license plates, it would encourage everybody else in the county to do the same, and then we'd lose our financial base and about $10 million a year in revenue, and that's why we did it to him. You think they're going to make admissions and statements like that? Well, of course not. Now, this is crucial because as you go along, you need to be setting this up. Now, when I went to jail over this very issue, this was the time when I was in there that, no, I take that back. This wasn't the time that I washed my face with my underwear. That's the better case. That one's still coming up. When I was put in jail on this case over here, it was for 12 days, of which 2 days were beyond the statutory limit. Now, let me just give you a little story about what came down pursuant to this case. This just happened 3 days ago. We're still in the middle of it. My opponents, of which there are 5 law firms, of which are the most prestigious law firms here in Boise, called me into a deposition because they wanted to question me pursuant to my claims. This is a very common procedure, and I knew what they were going to do. They were going to bring me in front of a recorder with sworn testimony, and they're going to ask me questions like, well, how much money did you lose? And prove to us that you lost that. Prove to us that you were working for this store or that store. And we want to see your tax returns for the last 5 years, and we want to see witnesses and one thing and another. In other words, they're going to make me, before they go to trial, come in and prove all of my allegations. And then what that tells them, the purpose for this whole charade is, that tells them whether or not they've got a chance to win. If they don't think they can win, then they'll want to negotiate a settlement. If they think they can win, then of course they'll just go forward and try to beat me. And so they brought me in, and remember, this is the case where I asserted my religious rights and refused to take the oath. But I didn't refuse to answer any questions. And here in Idaho, and this may be of some value to you wherever you may be, we have statutes that make provision for people that have religious hang-ups like I do. You know, you don't have to take an oath here in Idaho. You simply need to put yourself in the same jeopardy of perjury if you lie as you would be if you took the oath.